This is the California Civil Procedure Handbook Rules, Selected Statutes and Cases, and Comparative Analysis from 2007. And we left off on limited and unlimited civil actions. No. Actually, I think we're at personal jurisdiction at this point. 1. The California long-arm statutes, unlike many states which limit the basis of the court's personal jurisdiction by reference to specific statutory categories. The California long-arm statute, CCP 410.10, broadly states that a court of the state may exercise jurisdiction on any basis not inconsistent with the Constitution of the state or of the United States. Section 410.10 manifests the intent that California courts exercise the broadest possible jurisdiction over non-residents, limited only by constitutional considerations, and cites the Sibley v. Superior Court case of 1976. Due process minimum contacts is subpart 2. Under B, personal jurisdiction, minimum contacts, general versus specific jurisdiction. In Vons Companies, Inc. v. Seabest Foods, Inc. of 1996, the California Supreme Court attempted to clarify the personal jurisdiction concept of specific jurisdiction by defining the circumstances under which a cause of action arises out of or relates to a defendant's contacts with the forum. This was not an easy task. The court's discussion of the due process issue covers nearly 30 pages. See Vons Supra. The main focus of the court's analysis in Vons was on the nature of the nexus between the defendant's forum activities and the plaintiff's cause of action. The defendant in Vons had argued for the adoption of the proximate cause test formulated by the Court of Appeal, for example, unless the defendant's forum contacts proximately caused the occurrence that injured the plaintiff. The connection between the contacts and the claim is insufficient to permit the exercise of specific jurisdiction. The Supreme Court rejected the proximate cause test as too narrow and as inconsistent with fairness rationale underlying the specific jurisdiction doctrine. Likewise, the Supreme Court rejected as overly restrictive a similar test proffered by the defendant referred to as the substantive relevance test. The plaintiff in Vons argued that the required relationship between the defendant's forum contacts and the plaintiff's cause of action should be determined by an expansive but-for test, which focuses on whether the plaintiff's injury would have occurred but for the defendant's forum contacts. The plaintiff pointed out that the U.S. Court of Appeals for the Ninth Circuit employed the but-for test in its specific jurisdiction analysis in Chute v. Carnival Cruise Lines and Ballard v. Savage. Despite the federal court precedent, the Supreme Court in Vons determined that the but-for test was too broad and amorphous. Vons Court wryly observed that if the defendant is a lawyer who has received his or her legal education in the forum, that legal education may be said to be a but-for cause of any malpractice the lawyer commits anywhere in the nation, yet it hardly seems a sufficient basis for the forum to exercise jurisdiction. The Supreme Court ultimately concluded in Vons that the appropriate inquiry for specific jurisdiction was whether the plaintiff's cause of action has a substantial connection with the defendant's forum activities and defined substantial connection by reference to the facts of an earlier California Supreme Court decision, Cornelius v. Cheney, in 1978. The claim need not arise directly from the defendant's forum contacts in order to be sufficiently related to the contact to warrant the exercise of specific jurisdiction. Rather, as long as the claim bears a substantial connection to the non-resident's forum contacts, the exercise of specific jurisdiction is appropriate. The due process clause is concerned with protecting non-resident defendants from being brought unfairly into court in the forum on the basis of random contacts. That constitutional provision, however, does not provide defendant with a shield against jurisdiction when the defendant purposely has availed himself or herself of benefits in the forum. The goal of fairness is well served by the standard we originally set out in Cornelius and Supra. That is, there must be a substantial connection between the forum context and the plaintiff's claim to warrant the exercise of specific jurisdiction. In Cornelius, we held that a California resident could sue a Nebraska defendant in California for wrongful death in connection with an accident that occurred in Nevada. because the defendant was engaged in the business of hauling goods by truck and made fairly frequent deliveries in California, and the accident while he was en route to California for further deliveries was found. We found a substantial nexus between plaintiff's cause of action and defendant's activities in California. We explained that the appropriate inquiry is whether the plaintiff's cause of action arises out of or has a substantial connection with the business relationship that defendant has purposely established with California. We commented that, as we found, the defendant's activities are not so wide-ranging as to justify general jurisdiction. Then jurisdiction depends on the quality and nature of the activity in the forum. Okay, just citing this quotation. The cause of action arises out of or has substantial connection with the business relationship the defendant has purposely established in California or with California. We commented that if, as we found, the defendant's activities are not so wide-ranging as to justify general jurisdiction, then jurisdiction depends on the quality and nature of his activity in the forum in relation to the particular cause of action. In such a situation, the cause of action must arise out of an act done or transaction consummated in the forum, or defendant must perform some other act by which he purposely avails himself of the privilege of conducting activities in the forum, thereby invoking the benefits and protections of its laws. Thus, as the relationship of the defendant with the state seeking to exercise jurisdiction over him grows more tenuous, the scope of the jurisdiction also retracts, and fairness is assured by limiting the circumstances under which the plaintiff can compel him to appear and defend. The crucial inquiry concerns the character of defendant's activity in the forum, whether the cause of action rises out of or has a substantial connection with that activity, and upon the balancing of the convenience of the parties and the interest of the state in assuming jurisdiction. Citing Hansen v. Denkla of 1958. So convenience is an element balancing the convenience. Arising out of has a substantial connection but balances the convenience of the forum. The Court of Appeal below focused on an asserted lack of relationship between plaintiff Vons on one hand and defendants Seabest and WRMI on the other. The court suggested that this lack of relationship was critical in determining whether the claim was sufficiently related to the forum context to permit the exercise of specific jurisdiction in California. Contrary to the Court of Appeals thesis, however, the defendant's forum activities need not be directed at the plaintiff in order to give rise to specific jurisdiction. 1984 from Keaton v. Hustler magazine. And I believe that was the case with the Florida Keaton and the Hustler magazine and, I don't know, interview. No, I'm probably mistaken that with another case. Oh no, it says publisher that distributes magazines to the public in a distant state may be held accountable in the forum to damage the victim, defamation. I think that's right, even though they held the interview over the phone or something. Just as long as the magazine was sold in the forum state where the defamation affected victim. Anyway, Cornelius and Supra. Jurisdiction found, although the defendant's business activities in California are not directed at the accident victim. Now, the United States Supreme Court has stated more than once that the nexus required to establish specific jurisdiction is between the defendant, the forum, and the litigation. See Helicopteros Nacionales de Colombia v. Hall. And that was a case we read in Cotton Law. Or maybe it was Civ Pro, but Schaefer versus Heitner is also cited here. So these are cases previously read, and if at all possible, I'll try to point to them. At least they're in my civil procedure playlist. That last one, Schaefer versus Heitner, not between the plaintiff and the defendant. Okay, so more than one nexus is required, not just between the plaintiff and the defendant. Now, for the purpose of deciding whether a defendant has minimum contact or purposely has availed himself of forum benefits, the relevant contacts are said to be with the forum because it is the defendant's choice to take advantage of opportunities that exist in the forum that subjects it to jurisdiction. See Ashi Metal Industry versus Superior Court. I think that's the tire blowout case causing a motorcycle injury. And then Burger King Court versus Sect Supra. We're citing Helicopteros again and Schaefer again in the Vaughn's case. That Burger King one is the seminal case on minimum contacts, if I'm not mistaken. So the case notes and questions regarding Vaughn's. 1. General jurisdiction refers to those cases in which the plaintiff's cause of action did not arise out of or relate to the defendant's forum contacts and therefore requires continuous and systematic forum contacts to satisfy the due process requirements for personal jurisdiction. So that's general, is continuous and systematic. Helicopteros cites this Vaughn's, I think, in light of the analysis of specific jurisdiction of Vaughn's, under what circumstances would a defendant be subject to personal jurisdiction in California court under the concept of general jurisdiction. As the California Supreme Court in Vaughn's acknowledged, the Federal Court of Appeals for the Ninth Circuit employed the but-for test in determining the requisite nexus between the defendant's forum contacts and a plaintiff's claim for purposes of specific jurisdiction. The Vaughn's court rejected this interpretation of the due process clause and instead employed the substantial connection test. Until this nexus issue is conclusively resolved in the Supreme Court, the difference between California and federal court test provides an interesting reason for forum shopping, does it not, and how so? Okay, so when I went to law school, it sounded like specific context was established. This is a 2007 publication, so we might have a more recent case besides Vaughn's. Due process and the effects test is subpart 3 under part B, personal jurisdiction. And it begins with a case, Pavlovich versus Superior Court, which is long enough to justify another reading. So before we enter into raising the personal jurisdiction defense, code of motion to squash service of summons, or to stay or dismiss actions procedure, before getting to 5 forum selection agreements, and then reaching venue. So we're going to stop on page 76 for just a moment and come back to the Pavlovich case.